Yes, Mr. Cole.
My Lords, we were discussing the accounts rules, and I'm now going to turn to the related question of why the judge considered that a breach of the money laundering regulations should be equated with a breach of the accounts rules. And she dealt with this at page 99 of the core bundle, paragraph 74. We've just looked before the adjournment at 73, where and then the judge discussed the accounts rules. And then at 74, she said that in disciplinary proceedings, the effect of a breach of Regulation 14 of the MLRs is comparable to the effect of a breach of the accounts rules. The MLRs were also made pursuant to a specific rulemaking power, and they are not conduct rules. While Regulation 14 does not create an offence of strict liability, a breach of Regulation 14 is contrary to the professional standards of the profession, without the requirement of any further fault on the part of the firm, and in that sense it applies a strict liability standard. In my view, the MLRs are another example of the type of rule Virgin Leader, which is an exception to the general rule. And we have addressed that, my Lords, in paragraph 36 of our skeleton argument. We respectfully say that the analogy with the accounts rules is misconceived. As I've said, the accounts rules are not conduct rules. On the other hand, the principle with which we are concerned, Principle 7 and Outcome 7.5, is a conduct rule and falls to be treated as such. Now, the SRA could have enacted a practice rule, not a conduct rule, but a practice rule providing for strict liability in relation to the money laundering regulations. It has that power under the Solicitors Act of 1974, the Administration of Justice Act, but it didn't, no doubt for good reasons, because it has approached breaches of the money laundering regulations as a conduct issue, and one sees that in the way that it enforces them, as you already know. It only enforces serious breaches of the money laundering regulations. So in my respectful submission, the analogy, or there is no equivalence with the accounts rules. We are here concerned with conduct rules, and in accordance with the approach in Leader, which is the right approach in principle, Principle 7 and Outcome 7.5 must be approached as conduct rules.
Now, can you just make good the proposition you just had about the various powers the SRA has to legislate?
Yes, we've I'll take your lordship to
it may be in your skeleton.
Yes, paragraph 22A, page 29 of our skeleton, cites the relevant provisions, including section 31, which deals with solicitors, but there are equivalent provisions in relation to law firms under the Administration of Justice Act and the Legal Services Act. And for example, section 31 in relation to solicitors refers it to the power to make practice rules and conduct rules and other sorts of rules. And then section 32 deals with accounts rules. But we are concerned with conduct rules, as you know my submission is. So we've given you the references in 22A to the relevant statutory provisions.
So it all depends on which statutory power is being used.
Well, I would put it more broadly. That would be a technical analysis. What it depends upon is the SRA's assessment as legislator is how most appropriately to deal with the MLRs. It, in its judgment, has dealt with them as conduct rules, pursuant to the conduct rulemaking power, and they fall to be treated as such, as part of a general provision in Principle 4 and 7.5, which doesn't just relate to the MLRs, of course, but relates to every legal and regulatory obligation which a firm is subject.
Can I just ask, if you breach, or there is a breach of the cost rules?
The cost rules, yes.
Yeah. What are the sanctions available? Are they across the board? available on breach of the conduct rules?
Forgive me, look, when you look at the cost rules, do you mean in the civil procedure?
Sorry, yes, yeah.
In the civil procedure rules?
No, sorry, the ones, not sorry, not the cost, sorry, I meant the ones to do with ones that you've just been looking about, the accounts rules, sorry.
Accounts rules.
Yeah.
Yeah, well, a breach of the accounts rules can be the subject of a complaint to the tribunal, and the tribunal would have the power to sanction it accordingly.
And it has the full range of...
So full range of powers under section 49? Yes.
Yeah.
Under section 49. It could range from no order through to striking off. But the reality is, if you have a serious breach of the accounts rules, it would not, unlikely in my experience, to be brought before the tribunal as a bare breach of the accounts rules. It would be coupled with a conduct allegation.
In which case you then have to, you say, would have to be a serious breach of the accounts rules to warrant being a breach also of the conduct rules.
That is my submission. As with any other breach of the conduct rules, yes. But any accounts rules breach worthy of taking, being the subject of disciplinary proceedings, would by its nature be viewed by the SRA as a serious breach justifying action, and therefore engaging not only the accounts rules, but also the conduct rules.
I'm looking at the primary statute, and obviously accounts rules are separate. It's a separate section, and Parliament required the Law Society to make rules about accounts and trusts accounts. Everything else is under 31.
Yes.
But the Society may make, and I appreciate it now delegated to the SRA, Society may make rules for regulating in respect of any matter, the professional practice, conduct, fitness to practice and discipline of solicitors.
Yes.
Now, are they four separate categories with different thresholds?
Well, I submit that conduct rules are does have its own threshold. Yes, if it's to be the subject of disciplinary professional conduct proceedings, as my very clear submission is yes, it does have its own threshold. There are other rule-making powers, for example, in relation to professional indemnity, dealt with separately in section 37, page 1215.
Yeah.
But yes, if it's to be the subject of a professional conduct complaint, it's got to be serious and reprehensible.
But professional practice doesn't.
Well, professional practice, if it were to be the subject of a disciplinary complaint, would very likely be a serious failure that engaged with one of the conduct rules. But it doesn't have to be necessarily. I mean, you could have, I mean, so far as the SRA's policy is concerned, it would only be suited for serious, but a layperson who had a particular complaint about, let's say, a failure to comply with the insurance rules might bring the complaint to the tribunal. And if it's presented purely as a failure to comply with a non-conduct rule, then the question of seriousness would not arise at the stage of breach, but would be relevant to sanction. Yes, I'm told that professional practice in section 31, we would understand is referring to matters such as the authorization rules in terms of the criteria for being authorized. But these are, so it's not so part of my case to exhaustively define the other categories, but if you are looking at a conduct rule, then my submission is the approach to conduct rules per paragraphs 156 to 158 of Lead A applies. And we are looking at conduct rules. I don't think that is in dispute in this case. So as I submit, the SRA could have sought to give effect to the MLRs in some other way. They're not to be criticised for not doing so, because we respectfully say they rightly perceive this as a matter of conduct, the proper subject, the conduct rules, and therefore subject to the implications that go as a matter of law with the conduct rule, per the argument I have developed before lunch. Now, it's paragraph 75, the learned judge also relied on passages in the textbook by Mr. Gould, which you have, I took you to at the very beginning of my submissions. Perhaps I could ask you to go back to paragraph 75, page 99. If the court would kindly remind itself of what was said there, because Gould formed, I think it's fair to say, a very important part of my learned friend's submission before the judge below, and if you would be good enough, please, to remind yourself of paragraph 75.
Yes.
And we if we could go back to Mr. Gould's book, please, volume 5, tab 66, begins at 1645. If you can pick it up at paragraph 4.1. Mr. Gould says that 4 lines down, the conduct described, this is in the chapter headed misconduct. Chapter 4, 4 lines into 4.1. The conduct described in this chapter is that which involves culpability, in other words, misconduct. In this book, the term misconduct is used to describe culpable behaviour. Breaches of rules and codes usually result from misconduct, but need not do so. We're pausing there. That's correct insofar as he has in mind the accounts rules and other practice rules. And then continuing, such breaches may involve penalties even in the absence of misconduct. Conversely, misconduct may be punished even in the rare circumstances which it does not involve a breach of any rule or code. And then 4.2, the question of culpability is less central to the regulation of entities, and this is the key paragraph that my learned friend and the judge based her judgment on, my learned friend relies on. The question of culpability is less central to the regulation of entities than it is to individuals. For corporations, particularly, a rule breach may justify a significant penalty for the purposes of deterrence and public confidence without showing that any individual is culpable or that systems are inadequate. Principles of a practice may be penalised for breaches which are effectively failures of the entity without themselves being at fault. This may occur directly where the rules impose a strict liability for the compliance of the entity on its managers, or indirectly where sanctions have financial consequences for the owners of the entity's business. Now, Mr. Gould, we do not accept, I should make it clear, that this is a correct statement of the law, and Mr. Gould does not cite any authority or commentary to support the proposition that a rule breach may justify a significant penalty for the purposes of deterrence and public confidence, even where no individual is culpable and systems are inadequate. He appears to be positing a significant penalty when there is no fault in any way underlying the conduct. And Mr. Gould does not cite Lee Day or discuss it. The only example he gives in the commentary that follows is the accounts rules, which we have already discussed. And then if we can pick it up again at 4.8, this is under the section, the nature of the codes. Mr. Gould says at paragraph 4.8, towards the bottom of the page, about 5 lines up. The fact, however, that a rule has been broken is not the end of the story. It is necessary to establish whether the breach is sufficiently serious to justify regulatory action. Well, we certainly agree with that, my lords, and that's precisely what the tribunal did in its decision. And then over the pages to page 1650, the bottom of the page under the heading Rule Breach and Entities, at paragraph 4.19, we have essentially a repetition of the statement in paragraph 42, but again, no authority cited to support it, and the only example given relates to the accounts rules. So we submit respectfully that Mr. Gould's analysis does not support treating a conduct rule as a matter of strict liability in relation to a law firm without regard to considerations of seriousness and or reprehensibility. And the approach put forward in this chapter is actually contrary to the SRA's own enforcement policy, which does not contemplate enforcement action against a firm where no individual is culpable and there's nothing wrong with the firm's systems and controls. And we can see that, if we could go please, back to the authorities, volume 5, tab 58.
What did the tribunal say in this case about the conduct of Mr. Chateau? I appreciate he wasn't an individual respondent, he
Yes.
wasn't within the jurisdiction. But if we're looking at cases where there's a discussion about whether a firm should be held liable for something which has gone wrong, where none of the partners was culpable, is that a rather artificial way of classifying this case? Did the tribunal say nobody was to blame for anything, or just that nobody within their jurisdiction was to blame?
The tribunal's finding was that Mr. Chateau hadn't asked the question,
Yeah.
and he ought to have done.
Yeah.
And the firm therefore failed to take adequate measures. Now, it's not my submission that the tribunal found that no one is at fault. My submission is that the tribunal found what it found, which was that the conduct was not serious, reprehensible and culpable, such as to amount to professional conduct. The point I'm dealing with here is simply on the proposition of law on which the learned judge relying on Gould at paragraph 74, to the effect that it may be appropriate to impose significant penalties on law firms without regard to seriousness and culpability. In my submission, there is no support for that proposition in the law, and the tribunal was entitled. It didn't find that no one was faultless, but it did find that the breach wasn't serious, reprehensible and culpable, such as to amount to professional misconduct. And in so doing, well, as you know, my submission is, it directed itself correctly in law. And the SRA's own enforcement policy recognises that even in the case of law firms, considerations of seriousness are engaged when deciding whether or not, and culpability, when deciding whether or not the law firm should be pursued. And may I just give your lordships the reference for that, because I'm conscious of the time, but it's the SRA's enforcement policy, and the relevant section is at volume 5, tab 58, page 1465 at the bottom of the page, over to 1466, where you'll find a section, who is enforcement taken against? And there's discussion as to whether it should be against the individual or the firm. The SRA also makes an important point, I say respectfully, which requires an answer. In paragraph 33(6) of its skeleton, page 59, because your lordships will see that the SRA relies on the fact that under the Money Laundering Regulations, the Law Society, or in effect the SRA as its regulatory branch, it relies on the fact that the SRA is the supervisory authority for independent legal professionals that it regulates. And it has a duty under Regulation 24(1) of the Money Laundering Regulations to, quote, take necessary measures for the purpose of securing compliance by such persons with requirements of these regulations. And you've got Regulation 24(1) in the Authorities Bundle, Volume 4, Tab 45, page 1278. I wasn't, your Lordships may wish to look at it now. I wasn't going to take you to it, but you've got it, tab 45. Uh, 1278. The relevant page is 1278. And you see under the heading duties of supervisory authorities, the supervisory authority must effectively monitor the relevant persons of whom it is the supervisory authority and take necessary measures for the purpose of securing compliance by such persons with the requirements of these regulations. Now, this regulation does not, I submit, support the SRA's case. Compliance with the regulations may, of course, be secured through a combination of rulemaking, enforcement, guidance, and supervision. Rule 24(1) does not require the SRA to treat every breach of the regulations as a matter of professional misconduct or to prosecute every such breach, nor does it require the tribunal to treat every breach of the money laundering regulations as a matter of professional misconduct. You've already seen the guidance, which was quoted the tribunal's decision, to the effect that firms and solicitors are only required to report serious breaches of the money laundering regulations. And we've got the current guidance, just for your note, at volume 5, tab 60, page 156 of the bundle, but it's in the same terms that you've already read in the tribunal's decision. And this approach to the money laundering regulations accords with the guidance of the Financial Action Task Force, which coordinates global action against money laundering and whose recommendations were the basis of the European directive, which the money laundering regulations implemented. And I would like to take the tribunal, the court, to those, please. We've got them in volume 5, tab 59. A document headed Risk-Based Supervision from March 2021. And at 1473, it explains what the Financial Action Task Force, or FATF as it's often known, is. It's an independent, intergovernmental body that develops and promotes policies to protect the global financial system against money laundering, terrorist financing, and the financing of proliferation of weapons of mass destruction. The FATF recommendations are recognised as the global anti-money laundering and counter-terrorist financing standard. And then if we can turn forward, please, to page 1508. There is the section 3.7, how should remedial actions and available sanctions be applied in a risk-based supervision. And I won't read it out, but paragraphs 83, 84, 85, and over the page 87 and 88 explain that remedial actions and sanctions by bodies such as the Law Society should be applied on a risk-based approach. And in terms of paragraph 88, it is said that a zero tolerance or a zero failure approach should be avoided. You get that language over the page at paragraph 88 in the first line. And paragraph 152 at page 1536 touches on the same point. Under the heading in the middle of the page, zero tolerance or zero failure approach, which is counsel against. So, my Lord, I draw your attention to this because although the learned friend is right to say the Law Society is the supervising authority, there is nothing in the policy material before the court, in particular the recommendations of FAT, to support the proposition that every single breach, even not a serious one, of the MLRs must be dealt with as a conduct law, still less enforced in the tribunal and sanctioned. And with respect, the tribunal brought, although they didn't look at the FAT recommendations, I don't think we cited to them, they nonetheless brought that understanding in their experience as the expert tribunal, aided of course by the SRA guidance, which said that only serious breaches should be enforced. It brought that understanding to its disciplinary function when making the findings that it did make.
Then their expertise is in saying whether or not a particular breach is serious.
Yes.
We're not holding them forward as an expertise in the law relating to whether such charges should be brought at all.
No, it's expertise, as you're right, my lord. It's in assessing the seriousness of the conduct in the context of the particular law in conduct law in question. Still 7 and outcome 7.5. I only, all I seek to get from this is an answer to the learned friend's argument that in some way our approach cannot be reconciled with the fact that the SRA is the supervising authority. The regulatory context recognises that the supervising authority may not treat every single breach of the MLRs as a matter of conduct, indeed may not enforce it. That's as much as I seek to derive from it. Well, can I turn on to something perhaps a bit more central, which is the SRA and Beckwith?
Yes.
Now, you've got that at volume 4, tab 24. And we deal with this in paragraph 35 of our skeleton argument. On page 39. Now, and perhaps if we can just remind ourselves what the judge said at paragraph 71 as a reason for rejecting the firm's submissions. This is at page 99 of the core bundle. In my judgment, if I were to adopt Mr. Coleman's instruction, I would be rewriting the conduct rules and departing from the divisional court's judgment in Beckwith. A single High Court judge ought not to depart from the decision of the divisional court. Now, we respectfully submit that the judge's judgment has proceeded on a misunderstanding of both Lee Day and Beckwith. I know this court's not so much concerned with the issue of precedent, but it is helpful just to explore the boundary between the two cases and what Beckwith in particular decided, because the court in Beckwith made clear that it did not intend to depart from Lee Day. I'm going to go to the relevant provisions in a moment, but it's paragraphs 23 to 24 that will come to those. In that case, the divisional court was dealing with a very different problem than the one we're concerned with. Beckwith was not about whether conduct that was not serious and not reprehensible could give rise to breach of the conduct rules. It was concerned whether the code of conduct reached into, or to what degree it reached into the private life of a solicitor in respect of conduct outside work, because the tribunal had found that a solicitor who'd engaged in consensual sexual activity with a more junior solicitor after work drinks had breached the obligations to act with integrity and to maintain public confidence. It appeared on the findings that both lawyers had had too much to drink, and the tribunal specifically found that the more senior lawyer had not abused his authority, and it was not alleged the activity wasn't consensual. And the divisional court on appeal set aside the decision of the tribunal on the grounds that the conduct as found by the tribunal did not breach the principles, because those provisions, the principles, took their meaning from the detailed provisions of the code. None of the detailed provisions of the code on the tribunal's findings had been breached. Now, we're on this appeal are not concerned with that aspect of the decision, but it's dealt with at paragraphs 31 to 45 of the Beckwith decision. What we are concerned with is a preliminary argument that the court addressed, which was that the question of professional conduct or misconduct should be considered independently of the rules of conduct as a freestanding question. And your lordships will see from paragraph 14 of the Beckwith judgment at page 1065 how the argument was put. The first two grounds of appeal are to the effect that the tribunal erred in its approach to allegation 1.2 by not first considering whether the allegation amounted to professional misconduct, and by not then concluding on the appellant's actions, and by then not then concluding that the appellant's actions did not breach the standard of professional misconduct. On the appellant's submission, the notion of professional misconduct provides both a threshold requirement to weed out complaints concerning matters that are insufficiently serious to be the subject of regulatory sanctions, and also provides a boundary mark to mark the limits of regulatory incursion to the conduct that occurs outside work and otherwise in the course of professional life. That argument was rejected over the course of the next paragraphs up to 25. Now, it is true that the divisional court does appear to say, in parts of its judgment, that the concept of professional conduct has no part to play at all in construing and applying the 2011 conduct rules. And one sees that, for example, in paragraph 16, where it says, put another way, whether or not a notion of professional misconduct has any part to play in any particular regulatory scheme will depend on the terms in which the scheme has been made. There is no universal principle. And then paragraph 18, it is not for this court either to add to that approach, that's the approach under the statutory scheme, or otherwise to reformulate the statutory scheme which has been made under the 1974 Act. There is no basis in law to interpose any additional requirement into the handbook to the effect that before the tribunal could act, it had to be satisfied that the conduct which amounted to a breach of one or other of the 2011 principles also amounted to professional misconduct. And even if that were so, adding such a requirement would only serve to insert unnecessary uncertainty and complexity. In our view, it's essential that the statutory scheme of regulation made in the exercise of the powers of the 1974 Act is construed on its own terms and not by reference to concepts or formulae that are not part of the scheme. And then the discussion continues, but what can
pausing there, you say that paragraph is just wrong from start to finish.
We do submit that respectfully, my lord, insofar as it's saying that professional misconduct has no role to play. Yes, we do, for reasons I'll come on to develop. And then there's a statement to similar effect, beginning with great care in the last two sentences of 19. Now, I'll come on to why I say those general statements are wrong, but the ratio of this part of the decision we do agree with, because the ratio is to be found in the last few lines of paragraph 22. The sentence beginning, although although it's readily apparent from Rule 10 that some notion of professional misconduct is used to distinguish between those matters that can be addressed by the SRA and those which need to be referred to the tribunal, it's equally clear that for the purposes of proceedings before the tribunal itself, there is no freestanding, I emphasise freestanding, no freestanding requirement. The tribunal must first decide whether the conduct alleged amounts to professional misconduct before going on to consider the application of any of the principles set out in the handbook. Now, we agree with that. It's consistent with paragraphs 156 to 158 of Lead A, because as we saw when we looked at paragraph 157 in particular of Lead A, the question of professional misconduct is not to be addressed as a freestanding one. On the contrary, as the court said at paragraph 157 in Lead A, and I'm quoting, whether the default in question is sufficiently serious and culpable will depend on the particular core principle in issue and on the evaluation of the circumstances of the particular case as applied to that principle. And to give you the reference again, that was volume 3, tab 32, page 993. So Lead A doesn't say you look at professional misconduct as a freestanding principle devoid of any consideration of the rule of conduct in question. So the ratios of the decisions are consistent, but I do respectfully submit that the broader obiter in the remarks in the passages we've been looking at are difficult to take at face value as a matter of precedent, because it's clear from paragraph 23 that the court in Beckwith did not intend to cast doubt on the correctness of Lead A, to which it made only brief reference. And you can see that, my lord, at paragraph 23 to 24, where it begins at 23 by saying this conclusion is supported by the decision in Lead A. The appellant relies on the judgment in that case as supporting his submission that a discrete requirement that a conduct complaint is said to amount to professional misconduct. The circumstances in which the allegation in Day's case arose were complicated, and then missing a few lines, picking it up about the fourth bottom line. As to the first relevant allegation under Principle 6 of the 2011 Principles, the court concluded that the tribunal's use of the phrase professional misconduct had been no more than a proxy turn of phrase for whether or not the relevant principle had been breached. See the judgment at 102. Well, pausing there, you'll see no use of the word proxy phrase in 102 of the decision in Lead A. And then continuing on the second relevant allegation under Principle 5, the obligation to provide a proper standard of service to your clients, the court said as follows at 153, 155 to 156. The court has cut off the citation. It has not included the key passages from 157 to 158, from which one gets the statement of principle. And then it continues to say that the judgment in Lead A lends no support for the appellant's first two grounds of appeal. Rather, as that judgment makes clear, the requirement on the tribunal to supply the substance of the rules as they exist from time to time. Now, in cutting off the key paragraphs, 157 to 158, I respectfully submit the divisional court has failed to acknowledge that the earlier court in Lead A plainly did think that the concept of professional conduct has a role to play in interpreting and applying the SRA conduct rules. Paragraphs 156 to 158 of Lead A can't be read in any other way, even on their own terms, and not in the context of the other passages that we looked at either. And it's respectfully suggested, or submitted, that paragraphs 23 and 24, and in particular, the early cutting off of the citation at the end of 156, indicates that the divisional court in Beckwith did not correctly understand what the divisional court in Lead A had decided. That is perhaps understandable because the court in Beckwith was considering a different argument or different question, that professional misconduct was a freestanding requirement separate from the relevant rule, and that formed no part of the analysis in Lee Day.
I don't know what meant by a freestanding requirement. I mean, it's not, as it were, count 1 professional misconduct, count 2 breach of principle 7. The question is whether it's an essential element.
Yes. Well,
Beckwith says that it is, and you say that's wrong,
well,
which you're
but
entitled to do.
what Beckwith says is you don't ask us a threshold question before you even get to the rules. Is this professional misconduct? And we accept that. Lee Day, the Divisional Court, wasn't setting up professional misconduct as a threshold or separate question. I mean, I'm not going to seek to paraphrase what was said in 157, but the analysis in paragraph 157 at Lee Day is that you assess the seriousness and reprehensibility of the conduct in the light of the particular rule of conduct in question, not as a threshold question, but in the light of the particular rule. And I should say, if Lee Day is right, there is no challenge to the tribunal's approach to Lee Day by the SRA if Lee Day is right. And as you know, there's no challenge to facts, findings of fact either. So we say the ratios in Lee Day and Beckwith are consistent, the reasons I've outlined, that the wider obiter remarks in Beckwith are both contrary to Lee Day, but also, perhaps more importantly for this court, wrong in principle, because I invite you to accept that the law is as set out in paragraphs 157 to 158 of Lee Day, and that it applies with no less force to principle 7, outcome 7.5, than it applies to any other rule of conduct. And although the judge said at paragraph 71 that if she were to accept the firm's construction, she would be rewriting the conduct rules and departing from Beckwith, we respectfully submit that, in fact, the learned judge was departing from Lee Day, despite having said that Beckwith and Lee Day were consistent. I now turn to why we say Lee Day approach is correct as a matter of principle. Now the SRA has criticised in its skeleton the Lee Day decision on the basis that the divisional court did not explain, it has said, why it thought that it was appropriate to apply sharp, at paragraphs 156 to 158, to the SRA's principles of and rules of professional conduct. And the SRA also says that the Lee Day court did not explain the process of interpretation that underlay its approach. And that's paragraphs 51.2 and 51.3 of the SRA skeleton at pages 66 to 67. Now, we have identified the relevant principles of interpretation in our skeleton argument, paragraphs 25 to 27. And we, of course, rely on the conventional principles that they'll, of course, be familiar and their common ground. And it is, of course, common ground that the ordinary principles of interpretation apply to the interpretation of the conduct rules, which, as the SRA points out, have the status of subordinated legislation. It's also, of course, agreed that the rules must be construed in their context and in the light of their purpose. And I wish to draw the court's attention to 6 principles of interpretation that are of particular relevance to the interpretation of the conduct rules, including principle 7 and outcome 7.5. And I'm really simply here drawing out the summary of the principles set out principally in paragraph 25 of our skeleton argument, which was largely made by reference to Benyon. The first principle of interpretation is that the legal meaning of an enactment may be different from the grammatical meaning, even if the grammatical meaning is clear. I don't understand that to be controversial. May I give you the references to Benyon for your notes?
Yes, if you said there are 6 principles, are they 6 principles to set out in the skeleton?
No, not separately isolated in this
Right.
way, my lord.
Okay.
They're related points, but the one I've just stated actually is in the middle of paragraph 25, where it said the grammatical meaning carries great weight, but may be overweighed by other interpretive factors. We do cite that or state that in paragraph 25, and the key references for that. I'm going to give you more specific references than appear in our skeleton, so you've got the actual page number. It's Benyon, paragraph 10.4, page 1664. Paragraph 10.52, page 1666. And paragraph 11.4, page 1683. Now, it's said in those passages that the presumption in favour of the grammatical meaning may be overborne by other factors, but they must be powerful indeed, and that's obviously a point that my learned friend emphasises in his skeleton argument. The second point of principle is that the court must consider the context in which an enactment was passed to ascertain its meaning, even if the enactment appears clear and unambiguous on its face. And to support that point, so in other words, the context doesn't only become important where you've got what looks like an ambiguous provision. The context can disclose the ambiguity or the lack of clarity. And we've got that in the supplemental bundle, please, at tab 8. Page 90. Where you see under proposition 11.22 at the top of the page, context here is meant in its widest sense to include the context of the act as a whole and its legal, social and historical context. And my lords, I emphasise the word legal context in this context. And then at the bottom of the page, you see citation to the Viscount Simmons' speech in the Attorney General and the Prince of Hanover, where he said, words, and particularly general words, cannot be read in isolation. Their colour and context are derived from their context. Sorry, their colour and content are derived from their context. So it is that I conceive it to be my right and duty to examine every word of a statute in its context, and I use context in its widest sense, which I've already indicated as including not only other enacting provisions of the same statute, but its preamble, the existing state of the law, emphasise those words, other statutes in pari materia, and the mischief which I can, by those other legitimate means, discern the statute was intended to remedy. And then the authors comment, the importance of this case is that it indicates that the context is relevant not simply for resolving ambiguities and other uncertainties, but for ascertaining meaning, whether or not there is an ambiguity or other uncertainty, and indeed for identifying whether something is or is not ambiguous or uncertain in the first place. And that passage from Benyon was adopted and approved by the Privy Council in a decision that you've got at tab 3 of this, sorry, in tab tab 1. I'm told, thank you. Tab 1 of this bundle.
Yes.
And the relevant passage is at page 14, paragraph 38, which I'd invite. It's a joint speech of Lords Hamilton and Stevens, with whom Lady Black and Lord Lloyd-Jones and Lord Briggs agreed. It's paragraph 38, and you'll see at the bottom of the page the approval of the passage and Benyon that we've just looked at. And my lords, that's the Privy Council. There is also a subsequent decision of the Supreme Court by Coast Farms from 2021, which we've got at the next tab, which has a statement to the similar effect, although it doesn't refer to Benyon. May I just give you the paragraph reference to that, which is paragraph 6.
These are very well-known principles, but why are they relevant?
Well, they're relevant to set up the argument and the submissions I'm going to make, because what
The words cannot possibly be understood to mean, or cannot rationally be understood to mean, what Mr. Ozin says they mean.
well, they're construed in context. They don't mean what he says they mean. And having set out the 6 principles, I will make my submissions as to why.
All right, well, so far we're on number 1, the legal meaning may differ from the grammatical meaning.
There was 2.
That was
Well,
2.
that's one. We had the second one, my lord, was
Context is important.
yes. The third submission is that a principle is that the meaning to be attributed to an enactment consists not just of what is expressed, but what may properly be implied.
Sorry, say meaning.
The meaning of an enactment consists not just of what is expressed, but what may properly be implied. And my argument on construction, approach 1, does involve implying into the enactment the requirement of serious reprehensibility and so on. So that's an important point which I wish to emphasise. And if I may, the tab 8 of the supplemental bundle states the general point at the top of page 90, the general proposition.
That's the context.
No, sorry, no, that's not the right reference. I beg your pardon. It's It's 93. Forgive me. 93. Paragraph 11.51. And then over the page, a couple of pages, page 95. At the second hole punch from 95, the commentary states, it is suggested that the question of whether an implication should be found within the express words of an enactment depends on whether it's proper, having regard to the accepted guides of legislative intention, to find the implication, and not on whether the implication is necessary or obvious. And then the last reference on this third point of principle at page 97, just below the first hole punch. While it may be helpful to treat the words as incorporated, it's not essential. What is implied is a meaning and not necessarily a particular verbal formula. So I don't need to invite the court to incorporate words as such into the regulations, but a meaning, which is the meaning I've been submitting, ought to be implied in accordance with approach 1. The fourth point of principle, which is important to my argument on construction, is that when considering rival interpretations, regard must be had to the consequences of adopting each construction for the law generally. That will be a familiar point. The reference for your note is paragraph 11.6 of Benyon, at page 1686. The fifth point, also important for the submissions I'll come to, is that the general law of which an enactment forms part, and we've got this point in paragraph 26 of our skeleton, the general law of which an enactment forms part is an aid to interpretation. And if we can go back to Benyon, please, for this point. Page 1753, tab 68. You see at the top of the page that the interpreter should consider all admissible external aids of construction, including the state of the law before the act was passed. And we rely on that. And then at 1763, a few pages on, please, we've got paragraph 25.1. Under the heading Statute and Common Law Introduction, an act must be read and applied in the context of the general body of law into which it is assimilated. And in this context, we say that means the general body of law in relation to professional conduct. Ordinary rules and principles of the common law will generally apply to and may impliedly qualify, I emphasise those words, the express statutory provisions. And then you've got a citation to Lord Hope's speech in the Wisely case, a few lines down. As a general rule, Parliament must be taken to have legislated against the background of the general principles of the common law. It may be found that on examination of the statute that Parliament has decided not to follow the common law. In that situation, the common law must give way to the provisions of the statute, but an accurate appreciation of the relevant common law principles is necessarily part of the exercise of construing the statute, and that applies with equal force to rules such as those made by the SRA. And then 1766, please, if the court would please turn forwards a few pages. We've got at the bottom of the page, interpretation most consistent with the relevant common law. Where a new act is passed, it may be expected to fit into the wider legal framework. The courts will usually adopt the construction which is most consistent with the area of law to which the act relates. And then lastly on this point, over the page, if the court would kindly go there please, page 1767, under the heading Existing Law Qualifying Proposition Expressed in Absolute Terms. There are also many instances where the general law operating in a particular area will impliedly qualify the operation of an enactment expressed in absolute terms. Legislation takes much for granted. And the sixth point of principle is that it is a principle of legal policy that the law should be fair and just. That is another interpretive criterion. And the reference for that is Benyon 26.3, page 1776. Now, with those submissions in mind, we make three submissions concerning the proper interpretation of the SRA conduct rules, including Principle 7 and Outcome 7.5. The first, and this is paragraph 26 of our skeleton, under both the common law and the statutory scheme that's evolved from it, solicitors have been disciplined for serious and reprehensible conduct, not for lesser conduct. And we do submit that the conduct rules should be construed consistently with the common law approach. In paragraph 26, we have traced the evolution of the statutory conduct scheme. The starting point is the court's inherent jurisdiction to discipline solicitors for misconduct. The tribunal system evolved out of and built upon the inherent jurisdiction. and this is explained in Myers and Ellman, which we have, if we could go there please, at tab 1 of the authorities, bundle 1. The point in issue in this case was whether a solicitor was professionally responsible for the misconduct of his clerk. It was held that he was, and if we could, on the point that I'm concerned with about common law misconduct, if we could start please with the speech of Lord Wright at page 41. In the middle of the page, he explains what misconduct is and also how the statutory scheme has evolved from the common law. The paragraph beginning, in order to deal with the points of law decided by the Court of Appeal, it's necessary to explain briefly the nature of the jurisdiction of the court which the appellant invoked, and that was the court's inherent jurisdiction over solicitors. A solicitor was long ago held to be an officer of the court in the role which he was entered, and as such to be subject to the discipline of that court. The court may strike him off the roll or suspend him. For instance, the Court of Chancery might strike a solicitor off the roll of the court and order a communication of that order to be made into the courts of Westminster. There are many such instances in the books. And then we have the beginning of the statutory scheme. By the Solicitors Act 1888, there was established the disciplinary committee appointed by the Master of the Rolls from members of, or past members of the Council of the Law Society. The committee was charged with the duty of investigating complaints against solicitors and reporting their decision to the court, which could then, if so minded, strike the solicitor off the roll or suspend him. It was not until 1919 that the Solicitors Act of that year, the disciplinary committee was itself given the power to strike off the roll or to suspend or order payment of costs by the solicitor subject to the appeal to the court. But the jurisdiction of the Master of the Rolls and any judge of the High Court over solicitors was expressly reserved. Pausing there, my lords, that remains the case today. Section 50 of the Solicitors Act 1974 expressly preserves the inherent jurisdiction of the court. And the reference for that is volume 4, tab 41, page 227. That's also reflected in section 47.1 at page 1221. And then it continues, whether the court would now entertain an application to strike a solicitor off the roll or suspend him instead of leaving the matter to the disciplinary committee may be doubted. Well, again, pausing there are recent examples, or at least one I can think of, the case of Penner and the Law Society. We mentioned it in our skeleton, where Mr. Justice Newberger, as he then was, struck off a solicitor under the inherent jurisdiction. And then it continues, but alongside the jurisdiction to strike off the roll or suspend, there existed in the court the jurisdiction to punish a solicitor or attorney by ordering him to pay costs. The ground of such an order was the solicitor being guilty of professional misconduct, as it's generally called, not, however, so serious a character to justify striking him off the roll or suspending him. And
At that stage, those were the only powers available, weren't they?
Yes, yes. But the proposition I'm seeking to obtain from this case is that at common law, one sees this over the page. We pick it up at the bottom of page 42 and over the page. It's the entire passage really which has been sidelined, but you see, for example, just above the first hole punch, a mere mistake or error of judgment is not generally sufficient for misconduct, but a gross neglect or inaccuracy is a matter which it is the solicitor's duty to ascertain with accuracy may suffice. So at common law, it's clear from this case, and it's perhaps an obvious proposition, that misconduct is concerned with serious misconduct. And one gets the same point from the speech of Lord Atkin. Perhaps if I can just give you the reference in view of the time. It's his speech from page 102 to the top of 103. And then the bottom of 103 over to 10, bottom of, the bundle references for Lord Atkin, actually page 26, top of 26, down to the bottom of page 26, and over the page to 27, and also the top of 28. So I should also say that the link between the court's inherent jurisdiction and the tribunal is still maintained to this day. One sees, for example, that the Master of the Rolls appoints the tribunal members at section 46.2 of the Solicitors Act, which you've got at page 1219, tab 44 of the bundle. And then at paragraph 26b of our skeleton, we make the point that until 1933, the standards of professional conduct were determined by the common law. But in 1933, the Solicitors Act of that year conferred on the Law Society rulemaking powers. But it remained the case that both common law and statutory misconduct were concerned with professional misconduct, that is serious conduct, and that was the point that we saw emphatically made by Lord Elmsley in the Sharp case that we looked at earlier. And the connection between common law and statutory misconduct was also noted by Sir Thomas Lund in the first edition to the Professional Conduct and Etiquette of Solicitors, and we've set out the relevant extract in our skeleton at paragraph 26b. I won't read it out, but there's also observations to the same effect, which again we've set out in the judgment of Mr. Justice Coleman in the re-solicitor case. In paragraph 26a, we also cite the decision of the Divisional Court in Briggs and the Law Society. This is at the top of page 34 of the bundle, for the proposition that the essence of disciplinary proceedings is misconduct. I won't take you to the facts of that case, but one gets that proposition in paragraph 29 of the judgment of Lady Justice Smith. In paragraph 26d, we cite the case of Walker and the Bar Standards Board, decision of the visitors to the Inns of Court, for the proposition that professional misconduct only arises if the conduct is serious and reprehensible, such as to warrant the opprobrium of a finding of misconduct. I do ask you please to turn that authority up. It's at volume 2, tab 24 of the authorities. This is a decision of Sir Anthony May and two others sitting as visitors. In that case, just to explain it very briefly, the barrister in a criminal trial had put a question to an expert witness to the effect that he, the witness, had been dismissed for stealing information from his former employer without having a proper basis in his instructions or the evidence for the question. The barrister immediately withdrew the question when challenged by defence counsel and personally apologised to the witness, and there was no impact on the trial. And the issue was whether a failure to comply with a provision in the barrister's code of conduct could amount to professional misconduct if it was not serious. And the visitors, overturning the tribunal, held that it was not. And in doing so, it departed from a literal interpretation of the code of conduct, that's the bar code of conduct, to give effect to the intention that it be limited to professional misconduct. And if we could pick up the report, please, at page 506. At paragraph 8, you see the relevant rule in paragraph 708 of the code about having a proper basis for asking a witness a question relating to the crime, fraud, or misconduct, and so on. And in paragraph 9, paragraph 901.7 of the code provides that any failure by a barrister to comply with any provision of this code, other than those referred to in paragraph 901 above, shall constitute professional misconduct. And in paragraph 10, breach of paragraph 708J is not one of those referred to in 901.1. It would be necessary to revert to paragraph 901.1 later in this judgment. And so, on a literal interpretation application of paragraph 901.7, any other breach of the code, however trivial, would constitute professional misconduct, that cannot in all conscience be correct. The parties are agreed, and so is the tribunal, that some modulation of the literal interpretation effect of these provisions is required. The underlying reason why this is, as we accept, required is because consistent authorities have made clear that the stigma and sanctions attached to the concept of professional misconduct across the professions generally are not to be applied to trivial lapses, and on the contrary, only arise if the misconduct is properly regarded as serious. So that, although it doesn't repeat, it reflects the language of cases such as Sharp.
Which was that paragraph?
11, my lord. Page 507. And then paragraph 12 quotes from the skeleton argument of Miss Alison Foster QC, as she was now, I think, now Lady Justice Foster, to support the
I don't think so,
proposition.
but anyway.
Huh?
I said, I don't think so, but anyway.
Oh, I beg your pardon. I've made a mistake. Paragraph 18. Paragraph 12 quotes from her skeleton, and it includes internal paragraph 18 from her skeleton. The case law shows that the courts have been astute to differentiate the isolated or be negligent lapse from acceptable conduct from the serious kind of culpability which attracts the opprobrium of a finding of misconduct. And then we see, turning over the pages, that submission is accepted at page 510, paragraphs 15 to 16. And the solution provided as a matter of interpretation, a matter of implied meaning, one sees at paragraph 21, at the top of page 511, that the requirement is to import the concept of seriousness into paragraph 901.7. And then there's quite an extensive debate as to whether that was permissible as a matter of construction, looking at the rules as a whole. But the conclusion in paragraph 30 over the page is that it was. And on the facts, the appeal was allowed by reference to the criterion of seriousness. Now, in paragraph 126A of our skeleton, we have made the point, and this actually reverts to a question asked this morning, that a consequence of the fact that professional conduct is concerned only with matters that ought to be disciplined, or sufficiently serious and reprehensible to be disciplined, is that ordinary negligence is not misconduct unless it's inexcusable and regarded as deplorable by fellow solicitors, or in more modern language, pronounced a manifest incompetence. I've given the court the references for that. In light of my Lord Bean's question, we'll see if we can find anything further on that overnight. But you also saw it in Lee Day, in the tribunal's decision, where it made clear that ordinary negligence was not sufficient ground for a misconduct charge. And then at paragraph 24 of our skeleton argument, at page 31, so we're going backwards a page or two in our skeleton, we make the point that the fact that the rules of professional conduct are concerned only with serious misconduct is reflected in the SRA's own rules, policy, and guidance. I rely on all the references set out in paragraph 24, but if I may just take you to some examples, starting with the current SRA Code of Conduct, which we've got in volume 4, tab 53. Tab 53, volume, yes, it's volume 4 towards the back.
we go on to this, can I just give notice to the other side? You referred us to Walker, and Walker has at paragraph 12 quite a good back catalogue of decisions generally in the Privy Council. So that's who it usually was in those days, making comments. If any of them are thought to be out of context or inapposite or something, do tell us tomorrow. Otherwise, it's quite useful and saves one going to 6 or 7 different places in the appeal cases. Right,
Yes,
page.
page 1373, my lord. It's the first page of tab 53. And the point I'm making is that the SRA's own documents and policies show its understanding that only serious misconduct should be the subject of tribunal proceedings. And we see that, for example, in the last paragraph of 1373, which refers to a serious failure to meet our standards. And a few pages on 1379. Paragraphs.
Sorry, which edition is this?
This is the current edition. This is the one introduced in 2019. I rely on it to show the general understanding amongst both the common law and amongst those who regulate solicitors' conduct, which is entirely in line with the common law, that disciplinary matters are required to be serious. And one sees that also 1379, where you have reporting obligations at 3.9 and 3.10, which relate only to serious breaches.
But you would say, presumably, that the handbook, the conduct rules appear in the handbook, don't they?
Yes.
The handbook is the umbrella
Yes.
term. And there are various rules in that, including the disciplinary rules we looked at this morning,
Yes.
which I assume you would say that in construing the principles in the code, you've got to look at everything that was enacted in the same handbook, including the other rules.
Yes.
And the point I made this morning was that the rules themselves provide that there's a first stage to disciplinary proceedings, which is the SRA itself has to consider it
Yes.
and can sanction itself. That's right, isn't it?
It can, internally, yes.
But the threshold for it doing so, according to the rules we looked at this morning, was that the breach must be serious.
Serious.
So I assume you said that's a higher level of relevant context, as it's actually in rules that were made at
Indeed, it is.
same
Yes,
time.
yes.
But those are the rules now. I think you said you were going to get the rules that existed in 2011 because
We've got that. I think my learned friend had the.
Well, the bundle we have a page.
Yes, we've got the. My learned friend helpfully. I should have written it down at the time. But we have them at tab 51. I think of this bundle.
We do, but I don't think we have it. We don't have the equivalent. We only have the page, I think, which deals with when the SRA will not itself sanction, but take it to a tribunal, which is the next step.
Yeah.
The first step is what the SRA must. What is the threshold for the SRA sanction?
Yes.
One of those.
Let's see if we can. Right. Okay. But so perhaps if we can look into that further overnight, my lord. Can I also show you or give you the reference to the SRA's current enforcement strategy? We'll perhaps look to see if we can find the 2011 one. But the current one says that it focuses attention on serious breaches. And that's Authorities Bundle, tab 5, page 1458.
Tab 5.
Volume 5, my lord, sorry. It's tab 58. tab 58. Um, 1458. Just below the first hole punch, our approach to enforcement is to focus on serious issues. We focus actually on the most serious issues. And although this isn't the guidance that was enforced at the time, my lords, there's no suggestion that the approach has changed. It reflects, as I say, the common law approach as to what professional misconduct is. And if we could also go forward to tab 61, issuing proceedings in the Solicitors Disciplinary Tribunal. This is the SRA's guidance. Your Lordship see at page 1580, and, just above the first hole punch. The Tribunal imposes disciplinary sanctions after making a finding of misconduct. Well, that, we say, is absolutely right and supports our submission, or is certainly consistent with our submission, that when you're looking at conduct rules, you are looking at misconduct. A finding of misconduct is a finding that there has been a serious breach of our standards and regulations which apply to individuals and firms we regulate. And as we point out in our skeleton, the SRA itself uses the term professional misconduct to describe the situation where its conduct rules have been breached. And we've given an example of that in our skeleton. It's the Said case. It's paragraph 24 ref of our skeleton, where we give you the reference to the SRA itself using professional misconduct as a descriptor for rule breaches. So that's the first submission, that the common law and the understanding as to what professional misconduct means supports, as a matter of implication, our approach to the interpretation of the rules, which is essentially the lead A approach. That brings me to the second submission on construction. As we point out in paragraph 26C of our skeleton argument, construing principle 7 and outcome 7.5 is impliedly limited to serious breaches of the relevant law and regulatory arrangements reflects the purpose of the principles of the Code of Conduct and of those rules in particular. And we cite at paragraph 26C the judgment of Lord Bingham and Bolton in the Law Society case. You've already seen the relevant extract in the tribunal's own guidance. Then, of course, a tribunal may take account when imposing sanctions, or indeed when deciding whether or not to impose a sanction, the imperative that public confidence in the profession be maintained if it's been damaged. And as we say in paragraph 26C, no, that's not the correct paragraph, but we do cite in support of this argument the regulatory objectives and principles in the Legal Services Act 2007. If I could give your lordships the reference for those. Section 28 of the 2007 Act, Authorities Bundle Volume 4, tab 44, page 1255.
Great tab.
44, my lord. Page 1255 requires the SRA to have regard to regulatory principles, which include proportionality and that regulatory action be targeted only at cases where action is needed. That, we say, is relevant context to the making of the rules. So that is the second submission. that the purpose of the rules and the reason why the tribunal sanctions misconduct supports the view that only serious breaches of the rules are engaged by the rules. The third submission on construction, and this is paragraph 27 of our skeleton, is that to construe Principle 7 and Outcome 7.5 as applying to any breach of any legal or regulatory obligation would have unjust consequences, which the SRA, as a reasonable rule maker, ought not to be taken to have intended objectively, without at least making that intention clear. On the SRA's case, any breach of the regulatory and legal requirements applicable to a firm or solicitor's business are caught by Principle 7 and Outcome 7.5. That would include, as I think I mentioned in opening, any minor breach of employment law, health and safety. Also in relation to the MLR specifically, as we point out in our skeleton, there are some rules about record keeping for 5 years. So if one was a day out or didn't keep them for the full 5 years, that would automatically be a conduct breach on the SRA's approach. And we say it's unjust that Principle 7 and Outcome 7.5 should be engaged by conduct that is beneath the threshold of disciplinary action. It is, of course, entirely to be expected that lawyers and law firms, as a matter of professional conduct, are required to comply with the law. But in a disciplinary jurisdiction, the issue remains one of professional conduct, not civil liability or criminal guilt. And we do submit that it's undesirable that the stigma of professional misconduct should apply to solicitors and law firms whose conduct, as found by the tribunal in this case, does not meet the threshold for regulatory action. And the final point of construction, this is paragraph 28 of our skeleton, we make the point that disciplinary schemes that apply to professionals generally are concerned with misconduct and have seriousness threshold. Now that has prompted a detailed response in the SRA skeleton argument, paragraph 52, to the effect that each professional disciplinary scheme must be interpreted on its own terms. Now, of course, we accept that, but the simple point we make is that professional discipline across the professions is concerned with serious failures to meet required standards. The SRA has not cited a single example of a scheme where a professional may be found to have breached the conduct rules without some assessment being made of the seriousness of the conduct. If the SRA is right on the point of law, then this is a unique example of that. So we say for all those reasons that the statement of principle in paragraphs 156 to 158 of Lead is correct, and that it applies to Principle 7 and Outcome 7.5 no less than it does to any other rule of conduct.
Can you can we just go back to your skeleton,
Yes,
paragraph
Lord.
27p,
Yes.
page 36. You say that about 6 lines down, the SRA's position in the appeal is that a solicitor who inadvertently commits a minor road traffic offence would breach Principle 7. Can you show us that?
Well, the SRA has resiled from that now. So they now accept that Principle 7 only relates to offences relating to the practice. So that was its position below. Let me give you the reference there. But,
that was the skeleton argument on
below,
the appeal
yes,
to the
yes,
judge.
yes. The same point applies, though. I can think of examples of trivial breaches of laws that do apply to practice. Doesn't mean to say the law isn't important, but the breach may not reach a level of seriousness that justifies disciplinary action. That brings me to approach 2, which I can deal with briefly. We've dealt with it in paragraphs 29 to 34 of our skeleton, because we say if we're wrong on the point of construction, then the tribunal is entitled to decline to uphold allegations of conduct rule breaches that are not, in its assessment, sufficiently serious to warrant findings of professional misconduct. Now, the judge at paragraph 80 held that there was no statutory basis for such a discretion, that we submit that the jurisdiction is to be found in Schedule 2 to the Administration of Justice Act. If we can go, please, to Volume 4 of the authorities. Tab 43. Page 1250. This deals with the powers of the tribunal with respect to recognised bodies, in other words, law firms. And it provides, in effect, that if the tribunal is satisfied that a law firm has failed to comply with any requirement, which would include a conduct rule, then, and this is the tailpiece of 18.1, the tribunal may, if it thinks fit, make one or more of the orders referred to in subparagraph 2. And you see what those orders are. They include directing it to pay a fine, but also more serious sanctions. Clearly, one of the things the tribunal may do, although it's not spelled out here, is simply dismiss the allegation. If it decides that the facts necessary to prove it haven't been established, or that it's not sufficiently serious to warrant upholding it. And that is the short point on jurisdiction. The tribunal has also made tribunal rules under section 46(9) to 11 of the 1974 Solicitors Act. And those rules also apply to proceedings in relation to law firms. And we have those rules at Bundle 5, tab 56, if we could go to those, please. The overriding objective, this is page 1414 on the tribunal, is very similar to that which applies in the civil courts under the CPR. And Rule 4 provides the overriding objective, or the tribunal must seek to give effect to the overriding objective when it exercises any power under the rules or interprets any rule. Rule 4, this is page 1414, tab 56.
Yes.
We've got the overriding objective, which the tribunal must seek to give effect to when it exercises any power under the rules or interprets any rule. That is to be read with Rule 6 over the page, which provides that subject to the provisions of the 1974 Act and other rules or enactments, the tribunal may regulate its own procedure. And when we do submit that the tribunal, under the Enabling Act, which we looked at a moment ago, and under its own rules, does have power or vires to dismiss an allegation founded on a breach of a rule that the tribunal considers is not sufficiently serious to justify an adverse finding of misconduct and the opprobrium that is likely to attach to it. That conclusion, we say, is reinforced by other aspects of the tribunal regime. It's common ground, for example, that the tribunal can dismiss allegations as an abuse of process, or it can summarily dismiss proceedings, both at the outset or after a half-time submission. And we submit that the SRA has no principled answer as to why the tribunal can't do likewise at the end of the case, if it decides, as it did in this case, that the SDT had not acted, that the SRA had not acted in accordance with its own guidance, and that the case on its findings was not sufficiently serious, reprehensible, and culpable to amount to professional misconduct. We also point out We'll draw attention to Rule 13, which is at page 14.19, page 1419, Rule 13. This requires every case or every application to the tribunal to be certified as showing a prima facie case to answer. No, being certified as showing a case to answer, rather. That's 13.1 before it can proceed. Now, the SRA, in order to adopt a consistent position, is driven to say in paragraph 43 of its skeleton that the tribunal has no power to refuse to hear an application on purely public interest grounds. So it says even if the tribunal at the certification stage takes the view that, look, there may be a technical breach here, but it's so trivial, require weeks to try, it's disproportionate. The SRA says that even in that situation, the tribunal has no choice, if there's evidence of a breach, however trivial, to certify. We say that can't be right. Clearly at the certification stage, the tribunal can have regard to the public interest, including the seriousness of the allegation. And that power arises no less once it's heard the evidence as it had done in this case.
Under Rule 13?
Yes.
What, really?
Well, yes, I do submit that in the regulation of its own jurisdiction, if it's presented with an allegation of alleged misconduct that was trivial, a technical rule breach, but in relation to which it formed the view that it would never be sanctioned, doesn't amount to professional misconduct, it could refuse to certify. But more that I don't depend upon Rule 13 because I've got the wider points. But in paragraph 30 to 31, we give examples of the tribunal's practice of dismissing allegations founded on rule breaches that are not sufficiently serious to justify findings. Now, of course, the fact that there may be examples doesn't prove that they're lawful. I accept that, but you've already seen Lee Day as the leading example where that happened. We've cited two other cases that we're aware of, Pabler and Griddenrod. We've given the references. I don't propose to take you to those because you are interested, of course, on the point of principle rather than whether it happens in practice. Finally, on this point, as we submit in paragraph 32, we say it is important that the tribunal possesses a discretion to dismiss allegations that are founded on breaches of conduct rules that it considers are not sufficiently serious, reprehensible, and culpable to warrant the appropriate finding of misconduct. From a practical point of view, SRA decisions to bring disciplinary proceedings are not readily open to challenge. They can't be appealed. A judicial review would be the only remedy, but we've cited the case of Salem, which makes it clear, not surprisingly, that a judicial review of a decision to bring, by a regulator, to bring a claim before the SDT is difficult to challenge. I don't have time to take your lordships to that case, but the reference for your note is Authority Bundle Volume 4, tab 37, and the paragraphs are 56 to 57. Now, the court at paragraph 77 of its judgment, this is the judgment of Mr. Justice Lang, said that it agreed with the submission that the stigma of an adverse disciplinary finding is a serious matter, but the learned judge said this: the SRA guidance indicates that only serious breaches of anti-money laundering legislation will progress to disciplinary findings, which is a safeguard against overzealous enforcement. Well, the tribunal specifically found, or by implication found in this case, that safeguard had failed, because it found that the SRA had failed to comply with its own allegations. And the power, I submit, to dismiss allegations founded on breaches that do not warrant enforcement action does enable the tribunal to afford a solicitor or a law firm the full vindication that it may merit in an appropriate case. And finally, on this point, it's no answer for the SRA to say that the question of seriousness and culpability can be left to sanctioning, as that does not address the professional stigma that upholding allegations of rule breaches, even minor ones, or ones at least beneath the seriousness threshold necessarily entails. Lords, I can deal with grounds 2 to 4 in the time I have remaining. I'm largely going to stand on what's said in the skeleton argument, but if I could just make a few points, if I may, on
Yes.
ground 2, which is that, and the reference is paragraphs 40 to 47 in our skeleton. Ground 2 is that if, contrary to ground 1, the judge was correct on the point of principle, then the judge was nevertheless wrong at paragraphs 82 to 83 to quash the entirety of the tribunal's decision and remit the case to a differently constituted panel for reconsideration. We also say in the alternative, or indeed further, that the decision was unjust by reason of a serious procedural irregularity. You've seen what the judge says at paragraphs 82 to 83, page 100 to 101, and these paragraphs give rise to grounds 2 and 3. The short point is that the error of law, if there was one, was immaterial to the tribunal's findings of fact and provided no basis for interfering with them. The limited circumstances in which an appeal court may interfere with the tribunal's finding of fact and its evaluation of facts is set out in paragraphs 20 to 21 of the judge's judgment and are summarised in paragraph 44 of our skeleton. The court will, of course, only interfere with the finding of fact if the finding proceeded on an error of principle or falls outside the bounds of what a tribunal could reasonably and properly decide. And we have outlined the structure of the tribunal's findings in paragraph 41 of our skeleton. And you can see that it was only after it made its findings of facts that the tribunal turned to consider whether the breach of the regulations was serious, reprehensible, and culpable, such as to amount to professional misconduct. And that finding, and the finding that the SRA had not complied with its own guidance in bringing the case, is not affected by the error of law. And it remains relevant to the assessment of seriousness of the conduct and to sanction if this case is remitted. We also respectfully suggest that it's impossible to see why the judge thought that a differently constituted panel had to deal with the remittal. As errors of law go, it was a perfectly proper and reasonable one for a tribunal to make, based as it was on submissions made by the firm based on Lee Day. It in no way prejudices the ability of the same panel to deal with any further matters that ought properly to be remitted. And at paragraph 45 of our skeleton, we also respectfully submit that this aspect of the judge's decision was vitiated by a serious procedural error because the parties were not informed that the learned judge was considering departing from the common ground that remittal was unnecessary. And of course, the SRA had not appealed against any of the tribunal's findings or its evaluation of them. So we submit, and this is paragraph 47, that on the basis of the tribunal's findings, the judge ought not to have remitted the case at all, even if there was an error of law, because it's clear that the tribunal, having carefully assessed the facts over 6 days, considered that the breach of the MLRs did not require a disciplinary response. And I've referred you to the relevant parts of the tribunal's sanctions guidance. Alternatively, if any remittal is required, it should be confined to the question of what, if any, sanction should be imposed in light of the tribunal's findings of fact and the court's decision on the point of principle. Ground 3 is a related point. This is paragraphs 48 to 50 of our skeleton. We say again that the judge was wrong at paragraphs 82 to 83 to include within the scope of the matters remitted to the tribunal the question of whether principles 6 and 8 had been breached. And again, this aspect of the decision was unjust by reason of a serious procedural error. We say this was wrong for 2 reasons. First, of the judge's analysis of the point of law, it affected only the decision on principle 7 and 7.5, because the judge held at paragraph 72 that seriousness, culpability, and reprehensibility are relevant to principles 6 and 8. So that aspect of the tribunal's decision can't be faulted. And secondly, and in any event, the SRA did not appeal in relation to principles 6 and 8. Its appeal was confined to principle 7 and 7.5, and the reference for its grounds of appeal is Call Bundle, tab 8, page 154. Lastly, ground 4 costs. We submit that if, contrary to ground 1, the judge was correct on the point of law, and if, contrary to ground 2, it was appropriate to quash the decision and remit the case in its entirety to a new panel, the judge was nonetheless wrong to hold at paragraph 84 that the appellant must pay the SRA's costs of the proceedings before the tribunal. We respectfully submit that this was unreasonable because if there is to be a complete rehearing, the allegation may yet be dismissed on remittal. Alternatively, the tribunal may view the matter, continues to view the matter, is insufficiently serious to justify sanction, and may take the view, or continue to take the view, that the SRA has failed to follow its own guidance. So it was entirely appropriate, of course, that my client should pay the cost of the appeal, but not be ordered at this stage to pay the costs before the tribunal. So, my lords, in conclusion, we invite the court to allow the appeal on ground 1, the point of law, and to restore the order of the tribunal. If you dismiss the appeal on the point of law, we invite the court nevertheless to dispose of the appeal in a way that respects the tribunal's findings of fact and its evaluation of them. We say that whatever the position of the point of law may be, the tribunal clearly did not consider that the breach of the MLRs warranted a sanction. Therefore, the appropriate response of this court, I respect, would simply be to declare that there'd been a breach, but not to remit the matter for further consideration. But if you're against beyond that, then I would invite you simply to remit the matter to the tribunal to consider what, if any, sanction to impose in the light of the findings that it's already made.
And
we do so
then only in respect to Principle 7.
in respect to Principle 7.
Yes.
And we've set out this in further detail in our appellant's notice at page 9, in terms of the order we invite you to make. My lords, those are my submissions. I invite you to allow the appeal unless you have any questions at this stage.
Thank you very much. Ms. Butler.
No, thank you, my lord.
Mr. Eisen.
Lords, we appear to have but one good lectern to the council, so I
Make
see
an
if I
order for
can
transfer of the
take possession of it. Thank you very much. Before turning to the particular and the detail, I'm going to try to stand back and examine the essence, the burden of the proposition that the learned friend places before the court. And we would respectfully submit that it is a surprising proposition that a principle not to be found in the statutory rule-making provision or the rules made under it, but apparently ultimately derived from the Scottish case of Sharp back in the 80s, should be said to displace the grammatical meaning of the rules themselves. And indeed, as I understand the learned friend's submissions, the proposition doesn't just stay on the turf of legal services or SRA, SDT proceedings in particular, but it carries on to have effect in relation to any conduct rules. And I'll be examining quite what that means. But on the face of it, it has sector-wide, cross-sector application. The ultimate derivation of the principle appears to be the citation of the case of Sharp before the SDT tribunal in Lee Day, I think by Miss Robertson of counsel, which was then understandably taken up and considered by the divisional court. The wider proposition was, of course, examined in Beckwith, and we would respectfully submit, as your lordships would have seen, that it was decisively rejected. And we respectfully submit, rightly so. I'm going to try reasonably systematically to examine the rule-making powers and the relevant statutory and regulatory framework made under them. So that's going to be my starting point before I move on in due course to grapple with what we say the court should make of Lee Day and Beckwith and my friend's propositions in relation to his various grounds. So the starting point is the rule-making powers in question. And it will suffice, I think, to look at the powers that relate to solicitors and the powers that relate to firms such as Dentons. I think the court has glanced at them. Could I invite you to go to begin with the Solicitors Act, Authorities Bundle, tab 4, and page 12, page 1010.
Sorry, you mean volume 4,
Volume.
It's
page.
I beg your pardon.
It's
At any rate, it is. I think my volumes are not the same as your volumes, hence some difficulty.
40.
But it's page
41, tab
1210. And
Yes,
I think the court is there.
tab 14.
So the beginning of Malone Friend's argument is that these are rules concerned with professional conduct or professional misconduct, I think was the way that it has been put. We're looking here at the rule-making power applicable to the regulation of solicitors. And section 31 of the Solicitors Act bears the heading Rules as to Professional Practice, Conduct and Discipline. Subsection 1, without prejudice to any other provision of this part, the society, that's the Law Society, and the SRA as its appointed person carrying out the relevant functions, may make rules for regulating, in respect of any matter, the professional practice, conduct, fitness to practice, and discipline of solicitors, and for empowering the society to take such action as may be appropriate to enable the society to ascertain whether or not the provision of rules made or of any code or guidance issued by the society are being or have been complied with. The grammatical meaning of that provision is not to enable the SRA to make rules relating to professional misconduct. It enables it to make rules for regulating professional practice and conduct. The two are not the same thing. And then if one looks at the Administration of Justice Act provision, which the court will find at beginning of page 1, 2, 3, 4. We have at page 1, 2, 3, 5 the equivalent provision in relation to firms. 9.1a, the society may make rules, A, making provision as to the management and control of legal services bodies, which is the correct categorization of the appellant. And then over the page, goes on to say prescribing the circumstances in which, I should say it be, and then at D, regulating the conduct of the affairs of such bodies and sole solicitors' practices. So again, if one starts off with the rule-making power, it is not a power to impose rules relating to professional misconduct, some kind of defined term. It is a rule-making power to regulate conduct, a much wider term, which permits, respectfully submit, when read in the wider legislative context, a wide range of standards that can be articulated, the threshold of which, threshold that needs to be met in relation to which, must depend as a matter of logic upon the form of activity that is being regulated. The wider regulatory context has been touched upon by my learned friend in his submissions, and obviously by both parties in our written submissions. But for present purposes, the important element of it is that the SRA is under statutory duties both as the approved regulator under the Legal Services Act and also as the supervisory authority under the Money Laundering Regulations. So again, the starting point is the Legal Services Act 2007. I invite your lordships to go, I hope I've got the right tab 44, page 1255, 1255. And we can see section 28, the approved regulator's duty to promote the regulatory objectives, etc. Subsection 1, in discharging its regulatory functions, whether in connection with a reserved legal activity or otherwise, an approved regulator must comply with the requirements of this section. And it's going to be helpful to read the rest of it. The approved regulator must, so far as is reasonably practicable, act in a way which is compatible with the regulatory objectives and which the approved regulator considers most appropriate for the purpose of meeting those objectives. So pausing there, 28(2)(b) confers upon the Law Society and the SRA acting on its behalf a wide discretion to consider what is most appropriate for the purpose of meeting those objectives. In doing so, subsection 3, the approved regulator must have regard to, and I think pausing there, this is what the learned friend rightly described as a proportionality requirement, amongst other matters. A, the principles under which regulatory activities should be transparent, accountable, proportionate, consistent, and targeted only at cases in which action is needed. And B, any other principle appearing to it to represent the best regulatory practice. And with those words in mind, could I invite the court to go back to the provisions that are thereby engaged, section 1, which the court will find at 1251.
Yes.
Section 1, regulatory objectives. In this Act, a reference to the regulatory objectives is a reference to the objectives of, and the most material ones your lordships may consider in the current context is A, protecting and promoting the public interest, B, supporting the constitutional principle of the rule of law. D perhaps comes into protecting and promoting the interests of consumers. H, promoting and maintaining adherence to the professional principles. Professional principles are defined in subsection 3, and I, promoting the prevention and detection of economic crime. That is, as the footnote indicates, a comparatively recent introduction. It does have some consequences, and it applies to the specific context with which we are concerned. The professional principles in subsection 3, again, looking at the most pertinent provisions, the professional principles are A, that authorised persons should act with independence and integrity, and B, that authorised persons should maintain proper standards of work. And then perhaps one should read on C, authorised persons should act in the best interest of their client.
It's a very marginal point, but the one, the subdivision 1, little I, economic crime, appears to have been put in by a 2023 statute, so maybe
That is true.
pass that by.
Yes. It nonetheless reflects a focus stimulated by the Act itself, obviously, on that particular matter. There is a somewhat complex statutory route, but to cut a long story short, that provision, which your lordships will see is further defined in subsection 5, economic crime is the meaning given by section 1931 of the Economic Crime and Corporate Transparency Act. I don't think we've put these provisions in the bundle for the benefit of your lordships, but as I read it, the route so described engages the money laundering regulations, the current iteration, the 2017 iteration, and specifically the offence of contravening enhanced due diligence requirements in relation to PEPs, if I can use the...
Mr. President, we've got enough to cope with in this case. I can't see why you're telling us this in relation to a decision made before the 2023 Act. H, professional principles with subsection 3 are relevant. That's enough, isn't it?
It reflects the current focus and statutory obligations of the Law Society and the SRA acting under it, but I obviously accept the Lordship's point and I won't labour it further. And this is a point I think that we made in our skeleton argument at paragraph 33, 33.3 and 33.5, that if one looks at the professional principles, 3b, that authorised persons should maintain proper standards of work, on the face of it, that is not suggestive of a high threshold for regulatory intervention. It is suggestive of a need, a statutory obligation to make rules, to articulate standards that have the effect of promoting proper standards of work. Moving on to the second aspect that I mentioned earlier, that the Law Society is the supervisory authority under the Money Laundering Regulations. The starting point in the regulations with which we are concerned, the 2007 Money Laundering Regulations, is Regulation 24, which your Lordships will find at tab 45, page 1278. Invited your Lordships to look at it not long ago. So 24.1, duties of supervisory authorities and common ground that the Law Society is such a supervisory authority. A supervisory authority must effectively monitor the relevant persons for whom it is the supervisory authority and take necessary measures for the purpose of securing compliance by such persons with the requirements of these regulations. So, a simple point. The Law Society was obliged to introduce measures which plainly can include standards which have the effect of promoting the NLRs in a way that is both effective and involves measures that are necessary. I don't think I need to invite the Lordships to go to it, but under those regulations, the designation of the Law Society as a supervisory authority is contained in Schedule 3, paragraph 20, which is at Your Lordship's page 1280. There's a missing part to the root, which is that Schedule 3 is specified as having that function by Regulation 23, which we've not included. And may I invite you, Lordships, to go next to page 1269. An obvious but important point that we develop in the skeleton argument at, I think, paragraph 33.7. Lawyers are subject to specific obligations under money laundering regulations. And the starting point is in Regulation 3.1 itself. Application of the regulation, subject to Regulation 4, these regulations apply to the following persons acting in the course of business carried on by them in the United Kingdom, relevant persons, and then your Lordships will see the list. It includes, as I think we've singled out, financial institutions at B, but independent legal professionals at paragraph D. The definition in these regulations of an independent legal professional is to be found a few pages later at page 1271, and it is subsection 9. It's a form of words which I'm sure the court is familiar with. Independent legal professional means a firm or sole practitioner who by way of business provides legal or notarial services to other persons when participating in financial or real property transactions concerning, and then there's a list, and pausing there, for what it's worth, it is on the face of it a functional definition. So it is confined to acting in that particular capacity. The pertinent provisions appear to be, when one is looking at the facts of this case, A, the buying and selling of real property or business entities, and B, the managing of client money, securities, or other assets. I think the position before the SDT was that it was unspecific as to precisely which provisions were engaged, but it was common ground that the activity concerned was in-scope activity. And as we know, a notable element of it was that the firm assisted in the purchase of one property, high value property, and the aborted purchase of a second property, which resulted in the loss of a substantial deposit, which never came back. On the face of it, managing of client money, securities, or other assets may arise, because I think the position is that money was held on account with respect to those properties. So it wouldn't be simple client money on account. This was money in connection with the proposed transactions. And your Lordships will note that there is an extended definition in the foot of the subsection. For this purpose, a person participates in a transaction by assisting in the planning or execution of the transaction, or otherwise acting for or on behalf of the client in the transaction. So, pausing there, it is wide in its scope, although it is limited to specific activities, and it requires the Law Society and the SRA on its behalf to lay down effective measures to ensure that those who are regulated by the Law Society comply with those obligations. I should say in its essential architecture, it corresponds with the current scheme under the 2017 regulations that regulate independent legal professionals in a similar way, although the definition of independent legal professionals is to be found in a section by itself. And then we have the provision in question, which was held to have been breached by the firm, by the SDT, Regulation 14, which imposes a requirement of enhanced customer due diligence and ongoing monitoring. It's at page 1274, and the route through it is one starts off with subsection 1, a relevant person must apply on a risk-sensitive basis enhanced customer due diligence measures and enhanced ongoing monitoring in accordance with paragraphs 2 to 4. And at subsection 4, a politically exposed person is identified as engaging that requirement. A relevant person who proposes to have a business relationship to carry out an occasional transaction with a politically exposed person must, and the material provisions considered by the SDT are B and C that follow, take adequate measures to establish the source of wealth and source of funds which are involved in the proposed business relationship or occasional transaction, and C, where the business relationship is entered into, conduct enhanced ongoing monitoring of the relationship. And the SDT found that both of those provisions were of relevance and were engaged. A PEP is then defined, and there is reference to Schedule 2, which contained relevant provisions relating to persons engaged in banking. So, my lords,
Would that be a
note for the
convenient
time.
point at which to break off? So 10:30 tomorrow. Well, I should have